And now to talk about some of the latest in the legal battles over gun control in the state of Illinois, here for the Center Square Daily. It's Illinois in Focus, and I'm your host, Greg Bishop. Let's talk with Jacob Huebert, a counsel with the new Civil Liberties Alliance. Jacob, the Firearm Owner's ID card in Illinois has been around since the 60s. It requires everybody who wants to not just own, but purchase firearms and ammunition to have a card issued by Illinois State Police. It's been challenged in the past, but your organization, the new Civil Liberties Alliance, filing a federal lawsuit Tuesday. Tell us why this is significant.
Well, as you say, this has been on the books for decades, and it's a really extreme outlier among state laws regulating the right to possess a firearm. Illinois enacted this law in 1967. Massachusetts enacted a similar law in 1968. And no other state since then has gone so far in saying that you need the government's permission before you can so much as touch a gun in this state. And people have been decrying this as a violation of Second Amendment rights all along. But nobody until now, to my knowledge, has brought a federal lawsuit like this one, asking the courts to strike it down because it violates not only the Second Amendment, but also your right not to be deprived of your liberty without due process of law. To get the FOID card, they make you go to the Illinois State Police and go through an administrative procedure where the burden is on you the whole way to show that you're qualified to exercise this constitutional right, to satisfy them that you're allowed to do this. And that's just the opposite of how constitutional rights are supposed to work, of course. The whole point of a right is that you don't need the government's permission to do the thing. And yet Illinois makes you go through all of this, which could take months. Even if you go to court, the burden is still on you there. A court has no deadline by which it has to rule on this. And constitutional rights aren't supposed to be like that. You're supposed to be able to just exercise them. So we're hoping that the courts will finally end this now that we're squarely giving them this opportunity.
Now, Jacob, listeners, watchers, they're familiar with the Second Amendment. I could recite it for you. A well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. But what about the 14th Amendment? Explain that to those who may not be constitutional attorneys. Why is that significant in this question of, is a government-issued ID to exercise a right constitutional?
So the 14th Amendment says, among other things, that no person can be deprived of liberty without due process of law. At the time the Constitution was enacted, that meant nobody can be deprived of liberty unless the government goes to court and shows why that person should be deprived of liberty to a neutral judge. And the courts have gotten a little bit looser on that over the years as far as how much process you get and who has to give it to you and all that. But this is way beyond the pale, because here you're just automatically deprived of your liberty until you go satisfy government officials in the executive branch that you're entitled to exercise your constitutional rights. You know, if we didn't have the FOID law and somebody owned firearms and the government wanted to take them away, well, the government would have to go to a court and tell a judge why this person's gun should be taken away because they're dangerous for some reason. Illinois reverses that and puts you in a guilty until proven innocent situation, which is the exact opposite of due process. And that's an angle that other people haven't brought forward, but that's very important to us at the new Civil Liberties Alliance and should be compelling to the courts.
And you mentioned other cases that have been brought. We've seen the Illinois Supreme Court and state courts hear this challenge about the FOID card in several different venues, being one in particular, an elderly woman had a rifle in her home, and police were called to the scene after a domestic incident and found the rifle. She did not have a FOID card and was charged with a crime. And obviously that case, I think, has bounced up to the Supreme Court in Illinois now like 2 or 3 times. But this is a federal case. And if you could, tell us about the plaintiffs. There's 3 of them, and they all kind of have unique positions that they're bringing forward. Tell us about that.
Well, two of our plaintiffs, Christopher Laurent and Kim Dalton, would like to own a firearm, but they object in principle to this idea that they have to go ask the government's permission, and they refuse to even do it. They say we shouldn't have to go beg the government permission to exercise our rights, and we're not going to do that. They're not breaking the law in the meantime, but they're not going to do that. And so they say they should just be allowed to go get the firearm, to have self-defense in their home. And that's what they're asking for from the court, that they can just exercise that right in the same way that people in 48 other states get to exercise it, where they don't need to go get this permit first. Our other plaintiff, Justin Tucker, did get the FOID card. He applied for it in the summer of 2020 when things were getting pretty out of hand in the city of Chicago. And he thought, oh, maybe it'd be a good idea for me to have a firearm for self-defense in my home. And so he applied for the FOID card then. It took them 9 months to get it to him, but he does have it now. But there's still problems. One problem is the law says not only do you need to apply for and be issued the FOID card, but you have to have it on you at any time that you possess a firearm. And he objects to that. You know, that's a situation where essentially the government can ask you for your papers to see if you are someone entitled to exercise a right. And that, too, is not how rights are supposed to work in this country. And then the license expires after 10 years, and he doesn't want to have to renew it. He doesn't want to have to go through that again because he has the same objection as the other plaintiffs, that he should not have to ask the government's permission. And, you know, our client, Christopher Laurent, he's a Navy veteran. He is trained in firearms, has special certifications in firearms. No question, this is a law-abiding citizen, knows what he's doing with the firearm. Someone like this should, or like everybody else who hasn't actually done something wrong, should just be able to exercise their constitutional rights.
We're talking with Jacob Huebert with the New Civil Liberties Alliance for the Center Square Daily. And you had mentioned it took one of your clients about 9 months to get that FOID card approved. And that was around the time I remember covering this at the State House, Jacob. There were people coming up to me saying it's been more than a year since my renewal application's gone through. And state law prescribes a specific amount of time for applications to be accepted or denied, and it's like 30 to 60 days or something. Pretty remarkable. We didn't see a flood of lawsuits at that time. But what about this particular case do you think will be successful? And are you guys planning to go all the way up the federal judiciary to the U.S. Supreme Court if necessary?
Well, one reason why we should be successful now is because the Supreme Court in the Bruin decision a few years ago gave courts very clear guidance on how to analyze a Second Amendment challenge. The Supreme Court said, well, you look at, does this restrict the right as reflected in the text of the Second Amendment? And if so, was this kind of restriction something that was considered acceptable regulation of firearms at the time of the founding? Was something analogous done at the time of the founding, so that it was understood that even though you have the right, the government could do this thing? And here, well, certainly, of course, the FOID card requirement affects the right in the Constitution. It totally denies everyone the right to keep and bear arms completely unless until they get this card. And so then we look at, are there any historical analogs? Was there anything like what Illinois is doing at the time of the founding? And of course there wasn't. Illinois enacted this law in 1967, and it was the first law of its kind anywhere in the country for the country's entire history. There was never anything that required somebody to go get the government's permission before owning any firearm in the founding era. So if the courts just apply that in a straightforward way, it should fail under the Second Amendment. Then you also have this due process argument, which also should be very difficult for the government to overcome. So we're optimistic about that. And, of course, no matter who wins and loses in the district court, no doubt it will be appealed to the Seventh Circuit Court of Appeals. And no doubt if the government loses in the Seventh Circuit, it would probably want to take it up to the Supreme Court. And we would be thinking very seriously about that as well if it comes the other way. Hopefully that won't be necessary. It would be great if we could just win at the district court and Illinois gives up. But unfortunately, they tend to defend their firearms restrictions to the hilt. And so we will have to challenge them all the way as well if they keep doing that.
Jacob, having covered the issue of gun control and litigation against gun control and legislation for more gun control, I want to get your thoughts here about the supporters of a FOID law or supporters of other types of gun control laws. They talk about unprecedented societal concerns. They talk about self-harm that children may do if there's a proliferation of firearms. They raise a variety of different concerns about violence and inner city violence and things like this. What's your response to that?
Well, 48 other states managed to protect the public safety without anything like this FOID card requirement. So certainly you don't need a FOID card requirement to protect public safety pretty well. I mean, there's plenty of other states that protect public safety better than Illinois and the city of Chicago seem to do without any requirement like this. And yes, of course, there's always the risk that someone will do something bad with a firearm. But of course, criminals, the kind of people who want to go commit crimes, are probably not the kind of people who remember to ask the government's permission before they get the gun to commit their crime. The bigger effect here is, of course, on law-abiding people who are going to follow whatever the law is and either go get the FOID card, apply for that before they get a firearm, or, like two of our plaintiffs, just not bother to get a firearm at all because they don't want to go through this process. So there's no reason to think that this law is preventing much crime, but it is preventing people from exercising their rights. And of course, there are always public safety concerns around guns, but the Supreme Court has said very clearly that the Second Amendment made that choice for this country, that we think it's better for people to have the right to keep and bear arms. And Illinois doesn't get to second guess that as it has with the FOID card requirement.
Well, Jacob Huebert with the New Civil Liberties Alliance, a new lawsuit filed in federal court against Illinois' firearm owner identification card. We'll definitely be staying on top of that. Greatly appreciate you taking the time with the Center Square Daily.